Welcome, everyone. That was really loud. At least it was loud from here. I'm just going to say a couple of quick remarks. My opinion, my approach is always, this is not about me. This is not about Professor Kolenk. This is about the students. This is about the finalists. This is about you guys. But I do want to say just a few quick words. The first is I want to thank Professor Kolenk, Professor Cole, and Professor Erickson, who judged the semifinal round. So if we give them just a quick round of applause. Daniela Arcana is also somebody who worked really hard. Where are you, Daniela? You worked really hard to get this done. Do you all know how hard she worked? Yeah. You know, well, we were closed last week. You may not have noticed that. Part of the reason was that is because water came in on the 4th floor, and if you had walked onto the 4th floor, you would have passed out and died because it smelled horribly. And they had planned a whole bunch of everything over the weekend. And when Professor Kolenk reached out to me and said, can we do that? And I had to say no. They scrambled and got it together. So thank you. We really appreciate it. And I'd like to thank the board and all the 3Ls who have helped put this together, as well as all the competitors. Now, to the competitors, I think we really do owe a bit of thanks, because without the competitors, you two would not be here. In addition, even if you did not make it up to the final podium, I want you to realize that in your efforts to get here, that's where the success of your future lies. Success lies in effort. You keep pushing, you keep trying, that's how you get to be up here eventually. So thank you to all of the competitors. Last thing I want to say very quickly is, you may not know this, but I too was on Moot Court. I too sat up here. But unlike these folks, I did not make it to the final round. You two have both already exceeded what your dean has done. Any of the faculty in here, did any of you get to make it up to the final rounds in Moot Court? Professor Kolenk, Professor Erickson. So the rest of us, you have already exceeded us. So keep that in mind. You have done exceedingly well by getting to this place and being in front of this very august and impressive and scary panel. I would be scared. You are not scared because you know what you're doing. I would be very nervous. So I just want to thank you and congratulate you, and I'm going to turn it over to Professor Kolenk. Thank you, everyone.
All right, thanks. Well, so most of you know about the problem that you're going to hear today because you've lived it for a while. So I'll just give a very brief overview of that. But first of all, again, thank you, Dean DeVito, for being here. We are so honored to have the judges we have here. I mean, this year we really wanted to really step up the internal competition, and the way we were going to do that with the support of the great EC here, which I think definitely deserve a round of applause for all the work for all of it, was by starting by bringing out just some super high-rate judges. And Justice Quince, this is the first time we've had somebody from the Florida Supreme Court judging our final round. Her bio is in there. I won't repeat it, and she's not here to hear it anyway. But you know, I mean, she's the first African-American woman not only to make it on the second DCA, but also at the Florida Supreme Court and the first Chief Justice. So we're really honored to have her here. Judge Makar from the first DCA, he has actually had a relationship with the school over the years. He's been a big supporter. You can see he is ridiculously educated from UF too, right? MA, MBA, JD, PhD, pretty much every degree that he had, he took. And we wanted to round it out, right? We've got some state judges. We really wanted to bring a federal judge in, and we've got a great magistrate judge. And I want to thank Professor Cole for being instrumental in bringing Judge Barksdale here because she was able to reach out to her and make sure that we were going to have everybody represented here. So their bios are here. I encourage you to read them. They actually just switched up something in the back room with me. So even though we were going to do actually, I don't even remember what they switched up now. It may get a little bit different at the end when it comes to the Q&A session. I know you guys will have some great questions for them, so please don't be shy about standing up and asking a question at that particular time. So there are a lot of people to thank. Dean DeVito has really already done the thanks, but I want to actually just recognize Daniela Carcamo especially. There is no kidding. You guys, especially most of you were here competing. It took Herculean effort for her to figure out how we were going to take what was essentially a 4-day competition and jam it into really a day and a half. And we had a lot of discussion about it. Daniela was ultimately the one that came up with the best way to do it. I think it actually worked really well. I almost think maybe we should do it in 2 days next year. It was, no, apparently not. You guys didn't think so. And then having Professor Colin Erickson on the semifinal round was great. And so thank you for all that. So those of you who aren't familiar with George Janis, the gist of the story is that George Janis, poor George Janis, was pulled over in a routine traffic stop, I believe. It turns out that he had drugs on his person. He winds up going to the station, and some of his belongings were confiscated and brought down to the station to be inventoried, of course, from the government's point of view. And one of those was a cell phone. And there's some incriminating evidence on that cell phone related to racketeering charges that Mr. Janis winds up having to face. And this whole case really centers on a Fifth Amendment issue. Mr. Janis says that his Fifth Amendment rights were violated because when the agents were asking him some initial routine booking questions, I put it here because that's the whole issue, right? Were these routine questions? One of the things they wanted to know was whether he owned the cell phone or not. And they asked him that repeatedly. And so the petitioner is being represented, Mr. Janis is being represented by Michaela Kadriou. I got it this time. Excellent. Michaela was actually on our Zemer competition over the summer and was an oralist on that competition. She did a great job. And I guess it's no surprise that she's here in the final round, and you're going to see, if you haven't seen her argue before, why that is. She's representing Mr. Janis's argument that essentially is saying these were not routine booking questions. This was an interrogation, and you didn't get his Miranda warnings. So that's going to be her side. The respondent, the United States of America, is being represented by A.J. Hernandez. Coincidentally, he also was on the Zemer competition this summer. And by the way, did I mention that we won the Zemer competition this summer? We're the champions. In fact, I believe Maggie McComas, one of the oralists on the championship team, is sitting in the audience right now. Sierra's in Tallahassee, the other one, and Jana is next to her there. So we've got 2 out of 3 of our final team there. But he is representing the United States, and of course, this is a routine booking exception from his perspective, and he will explain to us why. So hopefully you'll enjoy the arguments. I don't want to drag it out any more. Daniela is going to be our timekeeper and bailiff. She's going to go get the justices. We're going to get some good Supreme Court oyez, oyez, and I'm sure we'll all be standing for that. And I just hope you enjoy the arguments. And I also want to do one other shout out to our marketing person, Nikki, who has worked also feverishly to try to get this advertised. We're going to have it videotaped. Hopefully you guys won't mind if that link is available to your fellow students who couldn't be here due to classes. And so that's where we're going to be. So thank you, Nikki, for that. And please give a round of applause to Nikki, too. All right, Daniela.
All rise. The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. We're here this afternoon on the matter of Janice versus the United States of America. Are the parties ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Petitioner.
My name is Michaela Cadrillo, and I represent the petitioner, George Yanis.
May it please the court, my name is AJ Hernandez, and I represent the respondent, United States of America.
Great. Petitioner, you may proceed.
Good evening, Madam Chief Justice, Your Honors, may it please the court. My name is Michaela Cadrillo, and I represent the petitioner in this matter, George Yanis. At this time, I'd like to reserve 1 minute for rebuttal. There is one issue before the court. Why the 14th Circuit Court of Appeals incorrectly denied the petitioner's motion to suppress the statements made regarding the ownership of the cell phone. As this is a question of law, the standard of review is de novo. Mr. Yanis asserts 2 reasons why this court should reverse. First, the questions asked by Officer Aronson were interrogative in nature and fall outside of the booking exception to Miranda. And second, this court should adopt a hybrid approach and find that the questions did not serve a record-keeping purpose.
Well, you say you are here about the cell phones. What was the nature of the actual question that was presented to your client?
The nature of the questions was pertaining to the ownership, whether he owned the cell phone.
Was it just the cell phone that was asked about, or was any other property?
No, Your Honor. He was asked about several items that was found on his person when he was arrested. And so turning to the booking exception, this court established in 1990 in Muniz that certain questions fall within the routine booking exception. And so officers are able to ask these questions, which are typically biographical in nature, without requiring a Miranda.
You suggested a hybrid approach, correct?
Yes, Your Honor.
Has any court adopted the hybrid approach that you ask us to adopt?
While there has not been a circuit to adopt a hybrid approach, the majority of the courts, in fact 10 have spoken on this issue, 9 of them adopt either the objective should have known test or the subjective intent test.
Why do you think none of those, you said 10?
Yes, Your Honor.
None of those 10 adopted what you want us to adopt? And they had some learned judges on those courts, right?
Yes, Your Honor, and this could be an opportunity for this court to create a uniform decision. As is clearly stated, there is a divide between the courts, and this could be the chance for this court to decide a hybrid approach that all courts can uniformly utilize.
Well, what do you consider to be the hybrid approach?
A hybrid approach would consist of all 3 tests. First, the court should look at the subjective intent of the officer that he has when making a specific question.
Now, the court has never said subjectivity comes in the Miranda analysis, right? In the regular Miranda analysis, neither the officer's intent nor the suspect's intent come into play, correct?
That is correct, Your Honor.
So we're introduced, the court for decades has said subjective intent does not matter at all. You're saying let's consider it as a factor now in this setting?
When this court stated in Miranda versus Arizona, it established the booking exception. And at that time, it found that these biographical questions were permissible in order to facilitate the bookkeeping process. However, over the years, officers have been taking advantage of this booking exception and utilizing remotely connected bookkeeping reasons in order to squeeze in certain questions to incriminate persons.
And what basis do you get that? I'm sorry.
For instance, in the Preston case, the court decided that an 18-year-old who was intellectually disabled, he was subjected to a question that had 2 possible answers. And either answer would lead to a self-incriminating response. And the court established that that was an interrogation and he should have been Mirandized. And that is similar to the case at bar because Mr. Yanis was subjected to a similar question. In asking whether the cell phone was his, it would lead to 2 possible answers. Either yes, it was his, and Officer Aronson, having 10 years of narcotics knowledge under his belt, having been previously warned by Officer Chuck, as indicated on page 12 of the record, that this was a person of interest, and having the motive and intent to elicit this incriminating response would get the answer of yes.
How do we discern the subjective intent of the officer?
The subjective intent can be seen in his previous experience, in his knowledge, and what he wanted to get out of this. For example, in the respondent's brief, they argue that this was to facilitate a record-keeping purpose. However, possession alone is enough to meet that requirement. Because
this subjective thing I'm kind of hung up on, because in the Fourth Amendment context, the court has said we don't look at the subjective intent of officers. In the Miranda context, we say we don't look at the subjective intent. Articulate for me why we should look at the subjective intent as any part of this hybrid analysis.
This court should look at the subjective intent so as to protect the constitutional freedoms of each person. For instance, as indicated on page 3 of the record, there was a memorandum sent out to every officer in this county. And in the memorandum, it stated a few things. 1, every officer was bound to the exceptions, to the hard and concrete lines of the booking exceptions. The questions, which admittedly are not part of the record, are presumed to be biographical in nature, and they are not to stray away from the types of questions. The only leniency that they are given is in the order in which to ask the questions.
Well, that may not necessarily be true based on some of the case law. Don't we have a case that involves a question about ownership of the premises? And the court found that that was a proper question, and certainly ownership of the premises is not biographical.
Yes, Your Honor, and you were speaking regarding the Peterson case, if I understand correctly. However, that case is different from the case at bar. In that case, it was necessary to ask whether the premises belonged to the individual because the officer had to serve the person with the warrant. In this case, the only aspect that is being served is to protect Mr. Yannis from losing his cell phone. However, possession alone is enough. And the court in Peterson also stated that the officers could not ask which bedroom belonged to the accused because the only thing that was necessary was to ask if the house was his.
Is there any significance that the officers didn't ask about the laptop, and that was part of what their knowledge was, that they knew the laptop had some information but they didn't ask about it?
There are a variety of reasons why they didn't ask about the laptop, but in keeping with what's listed in the record, the questions pertaining to the ownership of the wallet, the $100 bill, including the cell phone, those are what the petitioner, what Mr. Yannis is contesting
well, doesn't
today.
it make a lot more sense to objectively say an officer who is making an arrest and has to do an inventory, they just have to ask about everything that's within the reach of the defendant?
And they definitely...
Whether it's a gun, whatever.
Yes, Your Honor, and I apologize for overstepping, and they definitely could, but possession would be enough. For instance, in Alfred, the court stated that because the officers did not see the flash drive falling out of the person that was in the backseat of the car, they could not establish possession, and so, by default, the ownership question was allowed. But in this case, all of the items that came in with Mr. Yannis were on his person.
May I ask you a question? We had another case where we rejected sort of this, consider all of these circumstances, because every case is going to be different, right, in favor of a bright line rule. And in doing that, we said this. I'm going to read this to you, and then you tell me why we should reject a bright line rule here, okay? We said the lawfulness of a search, this is a Fourth Amendment case, would turn on a highly sophisticated set of rules, qualified by all sorts of ifs, ands, or buts, and require the drawing of subtle nuances and hairline distinctions. That ad hoc approach not only makes it difficult for the policeman to discern the scope of his authority, it also creates a danger that constitutional rights will be arbitrarily and inequitably enforced. So, in other words, there was a beauty to the bright line approach. Although some rights might be sacrificed, other rights will be protected. Why should we reject the bright line approach in favor of which this hybrid approach, it considers so many different factors and circumstances that are going to be so varied in every case?
Absolutely, Your Honor, and that goes directly to the heart of the issue. At the end of the day, what's at stake here are two things. The fundamental constitutional freedoms of Mr. Yannis, the right to not self-incriminate, and I apologize, Your Honor. May I respond? I see my time has expired. the fundamental freedoms of each and every American, and the risk that the property that they came in might be lost. And so in keeping these two things in balance, and understanding that yes, it is important to facilitate the bookkeeping procedure, Mr. Yanis asserts that this hybrid approach, although it might be new, may be the solution in eliminating future jurisprudence. And in adopting these, both parties benefit, because Mr. Yanis's rights would be protected, and the officers would be able to speed up and streamline the booking process. And so for these reasons, this court should reverse. Thank you.
Thank you. Respondent?
Good evening, Madam Chief Justice, Your Honors. May it please the Court. My name is AJ Hernandez, and I represent the respondent, the United States of America. The issue in this case is whether Officer Aronson's questions regarding the ownership of the cell phone fell within the routine booking exception to Miranda. As a question.
Let's just start right there then. What was the administrative purpose in asking about the ownership? I mean, it was obviously there. It could be part of an inventory of the items that were taken from the defendant or from the defendant's car. So what was the purpose of finding who owned it?
Your Honor, the purpose of this procedure was to accurately track the property that's coming into the police department. And
so you put on a form that all of these items were taken from the defendant, taken from the defendant's car. Beyond that, what else was needed?
Your Honor, establishing who the owner of the property is protects the property interest of the true owner. It's more accurate to track who the owner is of the property rather than just the property is there. Just simply tracking that the property is in there does not protect the rights of the true owner, and the true owner's rights to the property is superior to anyone else's.
Well, why not take custody of the property, Mirandize, and then ask the question?
Well, Your Honor, because those questions fall within the routine booking exception.
No. That's for us to decide. We'll decide what's within the exception. But why not, from a police practices perspective, say we take the items, we Mirandize, require Mirandizing, and then ask the question, is it yours? In other words, you've already taken control of the items, which is an important police practice, and allow the question to be asked after the person is apprised of their constitutional rights.
Yes, Your Honor, they could have. However, the Constitution only requires that an individual be apprised of their rights if they're subjected to custodial interrogation. While Mr. Janis was in custody here, he was not subjected to an interrogation.
Well, let me ask you this. How many items were found on his person or in his vehicle?
There was the cell phone, laptop, wallet, pack of cigarettes, and money.
And was he asked about the ownership of each item?
Yes, Your Honor, except for the laptop. The laptop, as far as the record
indicates... He was asked if he owned the cigarettes?
Yes, Your Honor.
But not the laptop. So why?
Your Honor, the record is not clear as to whether the laptop was in the interrogation room at the time and whether it was placed in that gray bin. The location of where the laptop was after the arrest is unclear. However, what is clear is that those items that they asked about were in that interrogation room. As far as all the items that were in the gray bin that is part of their standard procedure, they asked about those items.
You're calling it the interrogation room.
It is a room where individuals would be interrogated after they are Mirandized.
But this was also a booking room?
Yes, Your Honor. This is and I apologize for misspeaking. This is a room where they go through their booking procedure. As reflected on page 3, they have a memo from the Chief of Police that requires the officers to memorize a series of questions and requires them to ask these questions.
Same questions?
Yes, Your Honor.
Each time. So in one of our cases, we were talking about Miranda and said the paradigm Miranda situation is a person's arrested, we had that on the street, whisked to a police station, yes?
Yes, Your Honor.
Detention represents a sharp and ominous change, and the shock may give rise to coercive pressures. A person who's cut off from his normal life and companions and abruptly transported from the street into a police-dominated atmosphere may feel coerced into answering questions. Isn't that exactly what we have now?
Yes, Your Honor. He was in that type of atmosphere. However, just because the atmosphere alone was that way doesn't mean that he was being interrogated. The interrogation is determined by the type of questions that were being asked and whether the answers were testimonial in nature. Here, the questions were part of a standard booking procedure in Corson County that they were required to ask.
Did the officer already know that there was something on the cell phone?
No, Your Honor, not. The record is not clear as to that. Your Honor may be referring to the officer that reminded Officer Aronson before he went into the room to speak to Janice that he had been implicated in some drug conspiracy by a confidential informant. However, that officer did not remind him about anything that has to do with the cell phone or any potential evidence that would be found. What was
eventually done with the cell phone? Because it seems to me that in these situations, and you look at Rhode Island versus Ennis, which talks about an interrogation includes questions that the police should know are reasonably likely to elicit an incriminating response. And so if that is the case, if the officer had some knowledge that there was something on the cell phone that was pertinent to his arrest, the crimes for which he was arrested, asking that question, isn't asking that question reasonably likely to elicit an incriminating response?
No, Your Honor. In this situation, any reference to the cell phone or what potentially could have been held on the cell phone were comments made by one confidential informant during one interview 2 years prior to this interview, to this incident. So it would be unreasonable for this court to expect an officer to remember one specific detail from one interview 2 years prior, and which he was not reminded of that before he went into the room.
Didn't they know this particular defendant? And they had previous contact with him? Correct?
Yes, Your Honor. But that does not speak to the fact of whether the officer had any subjective intent or prior knowledge that reminded him specifically of any potential information that would be found on the cell phone. The officer did not have the subjective intent that the petitioner alleges to have to elicit.
How can you say that? It sounds like to me the officer who did the questioning specifically had information from a confidential source that basically said, check out the laptop, check out the cell phone, that's where the drug data is.
Well, Your Honor,
that sounds subjective to me.
The interview that Your Honor is referring to happened 2 years prior to this incident.
But it's people. I remember things 2 years ago, but I forget things from 2 years ago. But the record shows that this was a fact. That this officer had been apprised that this person has a laptop and a cell phone with drug deal information on it.
Was there a factual finding made by the district court on this point? Did the district court say the officer had a subjective intent?
Your Honor, the district court said that the officer did not have a subjective intent.
Okay, so are we stuck with that fact then? And you're arguing it doesn't, whatever, it doesn't matter really.
Well, the respondent's position is that he could not have had a subjective intent because he was required to ask those questions as a matter of procedure in that county.
Well, if the routine booking questions are biographical in nature generally, why was it necessary to ask about ownership of the cell phone? It seems to me that the officer that lists everything that was taken from the defendant without any regard to who may have owned them, but you would have a record of what was taken from him. How? It just doesn't seem like a routine booking question.
Your Honor, the routine booking exception does not include only biographical questions. As this court held in Pennsylvania v. Muniz, it involves biographical questions and questions that serve a legitimate administrative purpose. Here, the questions serve a legitimate administrative purpose, and as this court held in Rhode Island v. Ennis, they're also normally attended to arrest and custody in this county.
Yeah, but as your opponent just said, that was a sort of a different situation there because they had to have information about who owned the premises. And the court clearly said that when asked about was that his bedroom, that was outside of the normal booking questions.
Your Honor, that you're speaking, I believe, about U.S. v. Gaston. However, specifically in this case, where this court has held that the booking exception includes questions that serve a legitimate administrative purpose, and those legitimate administrative purposes are questions that are normally attendant to arrest and custody.
Just tell me briefly, what was the legitimate administrative purpose beyond listing of the items that the defendant that was taken from the defendant? What legitimate purpose was served by asking ownership?
Your Honor, may I conclude?
Yes.
The legitimate administrative purpose here was to track the property coming into the police department as accurately as possible. And the only way to do that as accurately as possible is ascertain the true owner of that property, so that if there is a third-party claim, then the police department can relinquish that property to the true owner. Your Honors, this court lets police departments formulate their own booking procedures as long as they're within the bounds of the Constitution. If this court were to rule for the petitioner, it would dishonor that tradition, and for those reasons, this court should affirm. Thank you.
Thank you. We have rebuttal?
Yes, 1 minute. May it please the court, there is one point. In addressing Chief Justice Quince's question, Mr. Yannis was arrested with 5 items in his possession. One of the items, the laptop, was lost. The administrative function of keeping account of all these items was abandoned. Of the 4 remaining items...
That's a very specific fact in this case. You want us to actually establish a rule nationwide based on this little fluke in this case that it was lost.
And further, yes, Your Honor, and further, of the 4 remaining items, 7 questions out of the total 20 that were asked to Mr. Yannis, 7 of them pertained to a cell phone that on the back had a sticker indicating that it was property of Garage Monkeys. As indicated on page 16 of the record, Mr. Yannis was the owner of that company. And so either way, if possession was not enough, he was the owner of the company. And so the United States do not have a legitimate purpose, and they did not accomplish it. For this reason, this court should reverse. Thank you.
Thank you both for your arguments. The court will now be in recess, and we will return shortly.
All right.
Please be seated. First, going to start with you, Professor. If you come up.
All right, so you want to do that? Okay. Before you announce the, okay. All right.
We're going to start this session with a little question and answer. If anyone has any questions they'd like to ask us about, I guess, what we do, or about oral arguments, or brief writing, anything that you feel the need to ask us about. Anyone? Yes.
Justice Quince, on average, how many oral arguments do you hear?
Oh, well, we have 1 week of oral arguments. When I first started on the court, we did 5 days a week, at least 4 cases each day. But you know, hearing oral argument cases is not the end of it. We have lots of other cases that we don't have oral argument on. So the court really has a heavy workload, but it's not just all oral argument cases.
And my court's very stingy about giving out oral argument. Even if you ask for it, it's only about 50% of the time that it's granted. There's a culture within my court to not grant OA. I'm not that way. I would rather hear from the litigants. So we usually sit 9 times a year, maybe hear 7, 8 cases each time, so do the math on that. That's the number of oral argument cases. But I vote in about 1,000 cases a year. We have 15 judges and about 5,000 cases, and that comes out with 3 judge panels. So about 1,000 votes in individual cases per year.
And I practiced on the 11th Circuit, and they do even fewer oral arguments. I think their percentage is 15% of the cases get oral argument or less, which makes the ones that get oral argument very interesting. Cases like this one.
We normally, if the parties ask for oral argument, we will normally give them oral argument. But you'd be surprised at the number of cases where the parties do not ask for oral argument. Any other questions? Yes. Gentleman in the back? Yeah.
Good evening, I'm Tom Burns. I have a question. What's your number one pet peeve about an attorney coming up and that's just something that really bothers you?
My number one pet peeve is a person arguing who does not know the record. You, as the party bringing the case, or on the other side of the case, should know the record better than I do. I should not be able to ask you a factual question about your case that you cannot answer. And I just hate it when they say, well, I really don't remember that. And, why not? You know you're coming to argue. You need to know your case. That's my pet peeve.
It's not so much a pet peeve as, I guess maybe it's a bothersome thing. Okay, when I was an appellate lawyer, I thought oral argument time was for me to explain to the court why I should win. And, you know, as a judge, I realized, no, my time as an appellate lawyer was writing the brief, and the court has read my brief, and oral argument is the court's time to ask what they want. So it isn't a time for me to give a soliloquy about why I should win. It's a time for me to listen very carefully to what the judges are asking, because the judges are deciding my case, and I better know what's concerning them. So I learned that lesson fairly early on, or maybe I get too late. But, maybe that's why I lost a lot of cases. But it's invaluable to know what the judges are thinking. So it's not time to go to your rote answers, and it's time to listen and respond to the questions the judges ask, and be candid with your response. No one likes an artificial response that glosses over the question. They want candidness.
I'm not an appellate judge, so I don't have an appellate pet peeve from a judicial standpoint. So I'll borrow my first boss, who's Judge Cox on the 11th Circuit. He's a gentleman judge. His pet peeve was to not answer the question. And whenever he asked a question, he really wanted to know the answer, like really wanted to. He barely spoke in oral arguments. So when he did, the really skilled lawyers would listen to the question intently, and they would not sit down until they answered that question, felt like they had. Those are the good lawyers. Very few of them would. They would sort of quickly try to answer the question and go right back to their argument. It would, drives a lot of appellate judges crazy, I think. They're not just asking questions to ask. They really want the answer. And then in the trial court, my pet peeve is facial expressions by counsel. At the lectern and at counsel table, there are people who are so expressive, and it's really hard for them to leave the expression at the door. But From, I just noticed that a lot, the eye rolling, the guffaws, that kind of thing bothers me.
You have a local rule on that, don't you?
We do have a local rule, yeah. It goes with courtroom decorum, and the courtroom decorum declines the lower you get in the court system, unfortunately.
We don't see a lot of that, but occasionally you will see attorneys who grimace and shake their heads and do things like that during the course of the other party's argument, which, doesn't endear them to us. I think, yes.
So my question is, when it comes to writing, with when working as a lawyer, writing your brief compared to the amount of time you spend writing an opinion as a judge.
I'm sorry, I didn't quite understand.
The amount of time spent writing. So, like, when you're writing your brief and you know that you're arguing for somebody versus when you're handing down a decision, is it like the same amount of time that you spend on it, same amount of time that you agonize over how you should be wording something to make sure that it's just right, or is it a little bit easier in one way or another?
Well, there's a deadline on appellate brief writing, and there's a soft deadline for appellate opinion writing. There's probably a reason that the historical motto of the courts in Florida are "Sat Cito Si Recti." Does anyone know what "Sat Cito Si Recti" means? It means soon enough if correct, which is, I guess, maybe an acronym now, saying justice takes time. It takes time to get the decision out. It takes time to think it through, to read the precedents, to write an opinion that is meaningful. So I'm probably, quote, slower than most on my court because I've spent a lot of time on the writing. If my name is on it, I've written it. Now, that's my opinion. It says per curiam. It's not something I've written myself. So I try to really take a lot of time when my name's on it. And that's the way it was as a brief writer. If I signed the brief, I wanted to put in the time on it to make sure it was acceptable quality.
I agree with that. I think it takes more time to write an opinion than to do a brief. I think you have a lot more leeway, literary license, whatever it is, when you're writing a brief. But when you're writing an opinion, you know that you are writing something that is for public consumption and going to be used and may be used, in other cases. And so you really want to try to nail it as much as you possibly can. So I think it takes longer. It's a longer process, at least for me.
Yeah, I would say it's equivalent. I actually do appellate work in a sense because Social Security decisions from the agency are appealed to us as magistrate and district judges, and I would say they're equivalent. When I was an appellate lawyer at the U.S. Attorney's Office, I would spend anywhere from, I got so efficient at some that it was a day that it would take to write a brief, but others were 2 or 3 weeks, so it just depended.
Hi, thank you all so much for joining us. I also have a writing-related question. Your honors have made it clear that oral argument is not a given and you're not guaranteed to have your time to advocate in front of the court. So with the importance of the documents that are submitted to the court, what is 1 or 2 very important considerations to think about when writing persuasively to the court?
Well, a couple of things I would recommend is never use the word disingenuous or adverbs. It's a lazy way of writing. First of all, disingenuous is mean. Like, look it up in a dictionary, and it's rarely used appropriately. So everybody, take it out of your vocabulary and don't use that word. It just makes you look like an amateur lawyer. But beyond that, adverbs are sort of an amateur writing style. And if you read writing experts, they very rarely will use an adverb. A book I like to recommend is Stephen King's On Writing. He's so popular now because the movie It. But he has a really good nonfiction book called On Writing, and he has a whole chapter on adverbs and how much he dislikes them. So these are the ly words. And instead of choosing those, which is a lazy way of writing, you really focus on the noun and the verb being used and really pinpoint it with exactitude. That's what I'd recommend.
I would recommend, as you're writing a brief, that when you are writing, the beginning of it is the statement of the case and the facts. The facts are very, very important. And I like brief writing to lay out the case as it happens, not as the witnesses presented it. There's a lot of briefs you see, you have witness A said so and so and so, and witness B said this, and witness C said that. Tell me the story of what went on in that case. Even if if the witnesses are out of order, it doesn't matter. Just tell me the story so that when I read it, I know what the story is and not necessarily what each witness said. I think it flows so much better.
I totally agree with that. I would say know your audience. In most appellate courts, your primary audience, at least initially, is the law clerks who have to read the briefs and summarize them. And secondarily, the judges. But that's important. You need to understand that. And also understand that as much as the myth has persisted in our judicial system that judges are all knowing and all omniscient about everything, we aren't. And we need to be educated. And if you have a case that is has some scientific issues or even some basic legal issues that aren't readily understandable, you have to write so we can understand them. We don't know everything. We don't know every area of the law. So, who's behind the curtain? Don't look at the man behind the curtain. So it's very helpful to make it simple and understandable and boil your case down to some simple, basic principles that you can that the court can decide upon. That's so important. Another thing is, I emphasized this when I was Solicitor General. We never had more than a 30-page brief come out of my office. If you're writing a 50-page brief, you're going to lose the reader's attention so quickly. You need to hone it down and make it no more than 30 pages. 25 pages is great, 20 even better. Some of the best lawyers in Florida, appellate lawyers like Barry Richard, his briefs are always like 22 to 24 pages, and he's a winner. He focuses on the winning arguments and is very, very good at it. So those are some quick thoughts on it.
The exception being death penalty cases.
Yeah.
So you don't have to hear those.
Right. Thankfully.
Those normally, a 20-page, 30-page brief is not going to do it because there are always so many issues in them. But in a normal brief, there's 2 or 3 issues. The more issues, the more things you throw in, the more you're going to detract from those that might be a winning argument. And so you want to present to the court those things that may, win the case for you, not the kitchen sink. So you need to know your record. You need to know what you should present to the court.
And I have one more tip. This is from the U.S. Attorney's Office and the Department of Justice and the Solicitor General's Office all use this tip. And you have such a good moot court team here. You're excellent, so I'm sure you already know this. But it's zeroing in on the standard of review. And then that standard of review has to show up in your issue statement, your standard of review itself, your argument heading, the very first line of every argument, and the conclusion. So the district court did not abuse its discretion in inventing something, or whatever that standard review has to be weaved in throughout the brief. And if you don't, then you're not applying the right law.
Well, yes.
I just want to know, when deliberating, how much does a public review take into consideration when you're writing your opinion or your decision? Like, court above you isn't necessarily opposite Supreme Court, and not as much, but people are.
Well, it becomes very important as to whether or not it's an abuse of discretion or some other standard. I mean, because the different standards require, say, deference to the trial court as to what factual findings there might be, but not for what the legal conclusions are. And so what the standard is becomes important in the final analysis.
One more thing, as someone in charge of helping to train these young, fine, new lawyers, what is one habit you would ask them to develop starting now as they go into their legal careers?
I'd say curiosity about the law. In other words, I think it should permeate everything they do. When I was in law school, eons ago, the only source of legal information was the National Law Journal. And as a total law dweeb, I subscribed to the hard copy of the National Law Journal as a first-year student because I wanted to know about every area of the law, and I just wanted to keep up on things and kind of get enmeshed into it. And as I developed as a lawyer, I got more curious about, well, why is there this doctrine? Or why is the statute read this way? And would research backwards to say, well, here's how it came about. So a curiosity about it and really a genuineness about wanting to engage in what lawyers do.
And I would say that no matter what issue you're dealing with, look at both sides of it. Because you're not going to do an effective argument for your side without knowledge of what the other side is all about. And even in situations where you may not have the best argument, or even the winning side, you may be able to make some policy arguments. So you've got to know what you're dealing with. You've got to know what the other side's arguments are going to be in order to make an effective argument yourself.
I would say never treat your adversary as the enemy. They're never the enemy. They have mothers and fathers, they have children, they have lives outside the law. When you treat your adversary as your enemy, it really becomes an unhappy profession. So the best lawyers in the state will argue before Justice Quince here, and then they'll go have a beer together and shake hands. Those are the very best lawyers because they know their adversary is just doing his or her job, doing it well, and their attacks go toward the arguments and the facts in a polite way and never toward the lawyer on the other side.
Well, if there are no further questions.
So we wanted to keep the suspense going. So first, before we have the judges announce their decision, there were a few gifts and another award that you didn't see presented tonight. And to present those things, I want to turn over the mic to the president of our Moot Court Honor Board, Vivian Gonzalez.
First of all, thank you guys so much for coming. The fact that you're here shows unwavering support for our program, and we are very, very thankful. Again, it's important to thank Daniela for putting this together. It's so difficult, so thank you, Daniela. We also want to thank the 2Ls who devoted their time and energy to preparing for this competition. I want you all to know that every single judge that benched you guys agrees how difficult it was to get these two to the final round. So give yourselves a hand of applause because you worked hard and you were amazing. We'd also like to thank Professor Cole and Professor Erickson for dedicating their time at the semifinal round. They were amazing. They picked our advocates here today. We'd like to give you a token of our appreciation, if you'd allow us. And just to keep the suspense going a little bit more, we're going to present the remainder of the gifts. Thank you. Thank you so much for coming. It means the world to us. This is fantastic that we were able to
get such a distinguished panel of judges to come to our school today and bench these amazing advocates. We could not be more humbled and proud to have you here with us. Again, a round of applause. We've got some kids.
Thank you guys so much for coming.
And lastly, before we get to the really good stuff, because appellate advocacy does require so much writing, as Justice Quince pointed out, sometimes advocates don't even get to argue, to do oral arguments. It's important to recognize the brief writing process as well. So because of that, we decided to present a Best Brief Award. This is going to be presented to the person who scored the highest in the internal competition among the 2Ls. This also was a very difficult decision. You all put in such amazing work. Your briefs were fantastic. And, but we did have to pick a Best Brief. And so the Best Brief Award is going to Andrew Moss. Thank you.
Thank you. So I'm sorry. I was like, take off and run.
Thank you so much again, and we'll turn it over to our distinguished panel.
I know you've all been waiting for this moment. I want to just let you know how proud we are to have been asked to participate in this final Moot Court round. It always is a pleasure for me and for the others here to participate with our law students. We know that we are looking at the face of the future of our profession, the faces of the future of our profession. And I want you to know how very proud we are of all of you, and especially those of you who competed a couple of times yesterday, and then this is the third time for our finalists today, and such stamina. And I want you to know how much we really appreciate your arguments and your poise and your presentations to us today. And if you would like to talk with us later for any individual feedback, we will be more than happy to do that. But now comes the moment we've all been waiting for. And I must tell you that this was a split decision. It was a very difficult decision for us to make. But we have chosen as the best oralist for this competition, Michaela Cadry.
We also have a presentation for our finalist, AJ Hernandez. And I don't envy the judges having a shift between the two of them all night long. I'll pin the name of myself. So at this point, after we get our final picture, I know that the oralists are going to want to take pictures with you guys afterwards, but why don't we close it out, just a few closing remarks once again. I said when you guys were in there in my introductory remarks, this is by far the most distinguished panel we've had at Florida Coastal. I know Judge Makar's been here before too, so he's been adding to our distinction. But we really, appreciate very dearly you guys coming out, and you've really honored us by your presence here. And we really thank you for that, especially going so late. I think you deserve one more appreciation. Thank all of you guys for coming and hanging in there through it all. And at this point, we will conclude our presentation and take some more photos. Thank you.